Are repeat offenders subject to harsh sentencing in Florida? Attorney Randall Haas explains that, depending on the crime, more and more crimes are being included in the repeat offender statutes. There is a whole range of different sentencing provisions that cover repeat offenders in the state of Florida. The most basic is the habitual offender law. Under this law, if the person has 2 prior felony convictions, one of which was in the last 5 years, then they are subject to twice what the statutory maximum would generally be. In other words, if it's a third-degree felony whereby an individual is generally supposed to have a maximum of 5 years, now his maximum is 10 years. If it's a second-degree felony, his maximum is 30 years rather than 15 years. You can also have exposure to what's called the Violent Habitual Act. That is, if you have a violent prior whereby you were either convicted or released from probation or incarceration within the last 5 years and you have a repeat offense, you're looking at a mandatory of either 5 years, 10 years, or life, depending on the degree of the felony that you now have pending before the court. For example, if you're charged with a third-degree aggravated assault and you have a violent prior in the last 5 years, you'll be looking at a mandatory 5 years with not a day less. The judge has no discretion or latitude to sentence you any less unless you're a youthful offender and you are sentenced before the age of 21. For a free phone consultation, contact Attorney Randall Haas in Fort Lauderdale, Florida at 954-256-8327 or visit his website at www.fortlauderdalecriminaldefenselawyer.us.